Okay, this is reviewer for admin law covering judicial review of admin actions. Okay. So section 1 of Article 8 of the Constitution says that judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been any grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. So, judicial review is under the admin code under section 25 of book 7, and it is defined under 4 parts here. Sorry. Judicial review. So, 1 under section 25, the decisions shall be subject to agency decisions shall be subject to judicial review in accordance with this chapter and applicable laws. Any party aggrieved or adversely affected by any agency decision may seek judicial review. An action for judicial review may be brought against the agency or its officers and all indispensable and necessary parties as defined in the rules of court. An appeal from an agency decision shall be perfected by the filing with the agency within 15 days from the receipt of a copy thereof, a notice of appeal, and with the reviewing court a petition for review of the order. Copies of the petition shall be served upon the agency, yada yada. Petitions for review to be perfected within 15 days from receipt of the final admin decision. So, agency decisions, appeal within 15 days from receipt thereof, and then petitions for review. And with the reviewing court, a petition for review of the order. The petition for review shall be perfected within 15 days from the receipt of the final admin decision, and only one motion for reconsideration may be allowed. If the motion is denied, the movement shall perfect their appeal during the remaining period for appeal reckoned from the receipt of the resolution of denial. If the decision is reversed on reconsideration, then the appellant shall have 15 days from the receipt to perfect their appeal. So that's the procedure for judicial review. Agency decisions shall be subject to judicial review in accordance with the admin code and applicable laws. Parties aggrieved by an agency decision may seek judicial review. Actions for judicial review can be brought against the agency, its officers, and any of the indispensable and necessary parties. If it's an agency decision, appeal within 15 days, and and with the reviewing court, you have to give a petition for review of the order. Oh my God. So much cat hair. The petition for review shall be perfected within 15 days from the receipt of the final admin decision. You're allowed one motion for reconsideration, and the motion, if denied, the movement shall perfect their appeal during the remaining period for appeal reckoned from the receipt of the resolution of the denial. So the filing of the motion for reconsideration would suspend the period for filing the appeal. Oh my God, there's so much fucking cat hair, it's pissing me off. The questions of law versus questions of fact. Judicial review shall be made on the basis of the record taken as a whole. The findings of fact of an agency, when supported by substantial evidence, shall be final, except when specifically provided otherwise by law. So questions of law versus questions of fact. Questions of law arise when there is doubt as to what the law is on a certain state of fact, while there is a question of fact when there is doubt that arises as to the truth or falsity of the alleged fact. For a question to be one of law, its resolution must not involve an examination of the probative value of the evidence presented by the litigant, but must solely rely on what the law provides on given the set of facts. So if the facts are disputed, or if the issue requires an examination of the evidence, then the question posed is one of fact. The test, therefore, is not the appellation given to the question by the party raising it, but whether the appellate court can resolve the issue without examining or evaluating the evidence, in which case it is a question of law, and otherwise it is a question of fact. Now, how do you determine if there is grave abuse of discretion? You determine this by looking at the overall evidence. If, say, the administrative agency was made without any substantive evidence to support it, if the findings are in the exercise of discretionary powers, Yeah. So if there's no substantial evidence on which the agency decision was based on, that is grave abuse of discretion. And the findings, this has to be a discretionary power when they're finding it. It's not ministerial. So there are three key cases here. Aboites, Diswanko, and Nepomuceno versus the Director, which talk about the use of remedies and administrative agencies, the question of law versus question of fact, and the ministerial versus discretionary questions. So, to look at when judicial review of administrative actions kicks in, there are certain questions that you have to remember again, which are what is an admin agency? So first, actually determine whether the body in question is an admin agency, because judicial review can over admin agencies should be from the action of an admin agency. Then you look at what power that body exercised. Was it QL or was it QJ? Determine that. And then you look at the proper remedies that are available. Is it a question of law or is it a question of fact? Is it Was it under QL or was it under QJ? Because QL would be certiorari or declaratory relief, right? And then QJ would be you'd have DEER, you'd have DPJ, and then you'd have certiorari under that. Yeah. The case of Cruz versus Cervantes. Here, Cruz filed an unlawful detainer case against the respondent Cervantes because the respondents were occupying certain properties upon agreement. But then, yeah. So it's a demand to vacate, right? The unlawful detainer. All right, great. Now, the MTC, the case was first brought to the MTC, but the respondents argued that the court actually had no jurisdiction because the proper court to decide it was DAR, because it was an agrarian case. So DAR has exclusive jurisdiction over agrarian cases. So the MTC agreed, but then referred the case to DAR, which then recommended the dismissal of the complaint due to lack of jurisdiction, which the MTC did. So the case eventually got to the Supreme Court, and the Supreme Court overturned the ruling of the Court of Appeals and affirmed the decision of the MTC. So actually, the Supreme Court said that it was proper for the MTC to refer the case to the DAR, but the MTC was not obligated to accept the recommendation of DAR to dismiss the case for lack of jurisdiction. Okay? Why? Because it was based on insufficient certifications. So in Cruz versus Cervantes, the general rule that we get is that findings of fact of an administrative agency is binding upon the court. The exception is if there is some grave abuse of discretion or if it's specifically provided otherwise by law. So if there's grave abuse of discretion, meaning it's not based on substantive evidence, or an example is that it's not based on substantive evidence, that it's not binding upon the courts. The courts are bound to comply with the referral to administrative bodies, but not necessarily bound to accept the recommendation if the determination of such recommendations was clearly errant. So as a general rule, however, the findings of fact of administrative bodies charged with their specific field of expertise are afforded great weight by the courts, and in the absence of substantial showings that such findings were made from an erroneous estimation of the evidence presented, they are conclusive and in the interest of stability of government structure should not be disturbed. Why? Because the specialized knowledge and expertise of the admin agency should be given deference over matters that fall within their jurisdiction. So a finding of law is not binding, but a finding of fact would be binding unless there is grave abuse of discretion because it wasn't based on substantial evidence. Now, just bear in mind whether there's a finding of fact or whether there's a finding of law. If it involves an appraisal of the evidence, then it is a finding of fact. The case of Remolana versus CSC, this one says that the findings of admin bodies are generally binding upon courts. We're good with this one. I'm okay with this. Like, Okay, the finding of admin bodies are generally binding upon courts. That doctrine. Remelena versus CSC, it's also stated in many, many cases. Ombudsman versus Reyes, this is a licensing case. And then the question was whether a violation of due process would warrant a reversal of a finding of fact. The general rule in Ombudsman versus Reyes here is that this is the one with like the LTO fixer case, right? It was discussed before, and he said that he wasn't Reyes properly wasn't apprised of the evidence offered against him because he didn't have access to basically the affidavit of the other person, and then that was used as a basis for his conviction, right, or for the finding of liability. So the general rule is that in reviewing administrative decisions, it is beyond the province of this court to weigh the conflicting evidence, determine the credibility of the witnesses, and otherwise substitute the judgment for that of the admin agency with respect to the sufficiency of evidence. So as to whether or not there's liability on the part of Reyes, that's not something that the court should be deciding because that's a question of fact. But if there's a serious ground to believe that there's a possible miscarriage of justice that thereby would result, then the court can weigh the evidence when reviewing administrative decisions. So, yeah. So would a violation of due process, because it was held that his due process rights were violated here, right? Would this warrant a reversal of the finding of fact of admin agencies? Yes, because due process must be followed. Otherwise, it's a grave abuse of discretion to render a decision that doesn't comply with due process. The case of Aboites versus Pepito, death is a question of fact and law. So it's a question of fact because how did they die, when did they die, etc. But it's also a question of law because the remedy would depend on what you raise in court. So how you're bringing this death to court, and what the legal effects of it could be would let you know what the remedy is. So also whether you're asking the admin agency to perform a ministerial or discretionary duty over the death. So may the findings of fact of an admin agency be appealable on certiorari or only questions of law? Let's go to the other cases because again, this Aboites, Tiswanco, and Villafuerte, ultimately it's going to be resolved in the last case. Aboites, Tiswanco versus Villafuerte, and Nepomuceno versus Duterte. Ultimately, it's going to be resolved in the last one. So just remember that these are the questions that are ultimately going to be tied together. Fact or law, ministerial or discretionary, and the remedies appropriate in each case. So in Tiswanco versus Villafuerte, here the RTC can't entertain petitions for certiorari for COA decisions. Why? The doctrine in this case in Tiswanco was that the RTC does not have jurisdiction to entertain a petition for certiorari over a COA auditor's notice of disallowance. Why? Because the COA is an independent constitutional body that has the power to define its rules and regulations, including the mechanisms by which a party may seek review for a disallowance like the one in this case. Nowhere in the process of appeal and review of COA decisions are RTCs clothed with jurisdiction to entertain a petition for certiorari. Only the Supreme Court has jurisdiction to entertain certiorari over a COA decision. This is evidently to the exclusion of other courts. So why can't it take jurisdiction? Because COA made a mechanism that said it would go to the Supreme Court instead. So raising a question of law over a notice of disallowance, however, issued by the COA auditor does not authorize a party to assail it in a petition for certiorari, while a notice of disallowance issued by a COA auditor has the force of a decision rendered by the commission itself. The remedy of appeal under the COA rules, which the aggrieved party can avail of, makes the notice of disallowance susceptible to review and modification. So based on this, it becomes apparent that as early as an examination is made by the COA auditor, by looking into the legal basis of an expenditure, as early as an examination is made by the COA auditor by which looking into the legal basis of an expenditure is made a part thereof, there already arises a question of law. So as soon as the COA auditor does the examination to look at the legal basis for an expenditure, there is a question of law involved. So the examination can involve a mix of questions of fact or law or pure questions of law. So in either case, the respondent cannot immediately assail the notice of disallowance in court via petition for certiorari because the criterion of pure question of law alone. So just because it's raising only a pure question of law doesn't mean that the admin agency can't answer it. Questions of law, again, arise when there is doubt as to what the law is on a certain state of fact, and a question of fact arises when there is doubt as to the truth or falsity of alleged facts. Okay, and then for the party aggrieved by the notice of disallowance issued by the COA auditor, their remedy is to file an appeal to the COA director that has jurisdiction over the agency under audit. Thereafter, the aggrieved party can elevate the matter before the Commission proper by filing a petition for review, and only after a decision is rendered by the Commission proper, that's when the jurisdiction of the Supreme Court can be invoked through the filing of a petition for certiorari under Rule 64 in relation to Rule 65 of the Rules of Court within a period of 30 days from the notice of judgment or final order or resolution sought to be reviewed. Then, lastly, in the case of Nepomuceno versus Duterte, this is ministerial versus discretionary. Petitioners must raise specific provisions of law that enjoin the respondents. So this is the one where the Sinovac vaccine was procured during COVID, and then Nepomuceno sought a writ of mandamus to compel Duterte and then Secretary of Health Duque to make the vaccines undergo more rigorous testing, right? Court ruled against Nepomuceno as the issuance of a writ of mandamus would not be justified because there was no ministerial duty involved here. So when you're talking about public functionaries, the term discretion means a power or a right conferred upon them by law or acting officially under certain circumstances uncontrolled by the judgment or conscience of others. On the other hand, a purely ministerial act or a duty in contradiction to a discretionary act is one which an officer or tribunal performs given a state of fact in a prescribed manner and in obedience to the mandate of a legal authority without regard to the exercise of their own judgment upon the propriety or impropriety of the act done. If the law imposes a duty upon a public officer and gives them the right to decide how or when the duty shall be performed, then that duty is discretionary and not ministerial. It is ministerial when the discharge of the same requires neither the exercise of official discretion or judgment. And remember, mandamus only for ministerial duties, cannot compel discretionary duties. Mandamus lies to compel the performance, and if it is a ministerial duty where performance is refused, then mandamus, right? But you cannot compel the performance of a discretionary duty, okay? Now, the writ of mandamus may issue in either of two situations. First, when there's the neglect to perform an act which the law specifically enjoins as a duty resulting from an office, trust, or tribunal. And second, when someone is unlawfully excluded from the use or enjoyment of a right or an office to which such other is excluded. So here, Nepomuceno versus Duterte, it's obviously contemplating the first situation. And under this, you have to raise a specific provision of law. You have to say, like, where is this duty that they're not performing? And then also why it's ministerial, which is, to let you know whether mandamus can lie. The case of Philcoa versus Primex also differentiates ministerial versus discretionary duties, but I'm gonna leave it there because that's the end of my finals coverage, I think. Because the next one is we're back to DEER and Doctrine of Primary Jurisdiction, which I already covered. So I think we're done. God bless. It's 4:13. My exam is at 6. I'm gonna go walk the dog now.